Okay, so we're going to go ahead and bring this meeting of the Board of Adjustment and convene, and if we can please all rise and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, welcome everyone. For those of you who don't know me, I'm Julie Johnson. I'm the chairperson of the board. I'm going to go ahead and do our roll call. I'm going to start with our Mr. Shuey, who's with us on Zoom.
Yes, thank you.
Here you
Hi.
are.
Hey, Dave.
Go ahead.
Rick Hardy.
Randy Wise.
Okay, and we also have,
Fred Townsend, Town Solicitor.
Bill Zolper, Town Manager.
okay. And I hope everyone has had, the board members have had an opportunity to look at the agenda. Can I have a motion to adopt the agenda, or are there any issues with the agenda as is? I have a motion to adopt?
A motion to
Move to adopt.
Second?
Second.
I got a second. All in favor?
Aye.
Aye.
Okay. So the agenda is it. So at this point, we're going to go ahead and open the public hearing with regard to the application for the property located at 2009 Coastal Highway, which everyone is fondly known as the Starboard. So we just for the record, there are 4 requests for variances. I'm going to just summarize. To convert the permanent outdoor tent approved from the board's May 5th, 2023 written decision to a weather-resistant pavilion structure with fire suppression sprinklers. Also to a variance or special exception to expand that covered outdoor area in that same decision from 1,200 square feet with 9 dining tables to 1,579 square feet of covered outdoor dining area with 11 dining tables. A request for variance or special exception to continue the relief from the off-street parking requirement previously granted by the board for a legal non-conforming restaurant with more than 4,000 square feet of patron use area. And finally, a request for relief to permit an expansion or addition to a non-conforming restaurant or outside service area to permit the construction of a 1,579 square foot pavilion. So those are the issues that we're going to be dealing with today. If we can have,
Ms. Johnson,
yes.
can I go ahead?
Yes, please.
So what I'd like to do is, it's been a while since we've met.
It is.
I'd like to remind everyone of what our authority is here and what standards we are to apply. And if during the course of the meeting we want to revisit that, of course, just ask.
Well, and I think, Fred, it would be helpful because of the language to make sure the board, all members understand because we've got a request for a variance, then we've got a request for a variance or special exception for 2 of them, and then a request for relief. So making sure that the board members all understand what those different terms mean. Because I think, we're used to the variance terms, but this language, I just want to make sure that we're all on the same page.
So one quickly I can deal with, which would be the item D is a request for relief. That is, those words are not meant to have a different meaning than a request for a variance.
Okay.
That's just a different.
Okay, that's helpful to know. I just want to make sure we're all the
That's
same.
not a different animal.
Okay. And I didn't think so, but I want to make sure we're all clear.
Well, you're clearly paying attention, so. Commend you
I
for
try, even jet lagged, I'm trying.
Okay, so back to the basics. The Board of Adjustment is authorized with certain powers. Tonight, we're hearing applications for variances. The Board of Adjustment is authorized with regard to variances to authorize in specific cases. This is, by the way, Chapter 185, Section 66, powers. Subsection C1, to authorize in specific cases such variances from any zoning ordinance, code, or regulation that will not be contrary to the public interest, where owing to special conditions or exceptional situations, a literal interpretation of any zoning ordinance, code, or regulation will result in exceptional practical difficulties for the owner of the property, so that the spirit of the ordinance, code, or regulation shall be observed and substantial justice done, provided such relief may be granted without substantial detriment to the public good and without substantially impairing the intent and purpose of any zoning ordinance, code, regulation, or map. So I apologize, that's rather lengthy.
It's a lot of words.
That code provision refers to a phrase, exceptional practical difficulties, which has been interpreted by the Supreme Court to mean the following, that for area variances, the Board of Adjustment is to consider whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. This should sound familiar. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And lastly, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is only met when the difficulties alleged are practical rather than theoretical and exceptional rather than routine. This is also the consideration where the board will ask whether more relief is being requested than is minimally necessary to relieve the asserted difficulty.
Thank you.
Thanks. I will note that with regard to both the ordinance and the quick check factors, there are references to relief from the zoning ordinance, code, or regulation, and I'll ask you to focus on that as we consider this application. So those are my introductory remarks. I don't know if you want to go directly to the applicant or if Dawn has anything introductory she wants to offer.
Yeah. Dawn, do you have anything that you want to say before we get started with the applicant's presentation?
She may be here just as a resource, so she may not.
No, I know. I know. I see her. There she is.
There you are.
Dawn?
She's frozen.
She is frozen. Oh, there you
Oh,
are.
there's her.
Anything you want to say before we let the applicant speak? Oh. No,
No,
that's not going to work. It looks like you're having computer difficulties. Yeah, we can't. You're breaking up. We'll come back to you. We'll see if you can. Dawn, we're going to come back to you. You're breaking up. We can't understand what you're saying. So maybe you can disconnect and reconnect and see if you get a better
connection.
connection.
All right, let's.
Okay, so we're going to go ahead and go to the applicant.
Must be the drones over New Jersey.
Exactly.
I have nothing additional to add.
Okay. Nothing to add, then we at least got that. Okay.
Yeah.
We'll talk to you in a little bit.
Good evening, Madam Chair, members of the board, staff, and the public. My name is Glenn Mandalis. I'm an attorney with Baird Mandalis, Broxton.
No, I do not.
And we have offices located up and down the state, newly in Maryland, but most close to where we are tonight. We have an office in Lewis on Savannah Road. With me this evening is Matt Parsons and Heather Morrison from Fisher Architecture. I'm here to answer any questions that you might have. They've done the renderings that you've probably seen and all the work sort of leading up to this. And of course, Mr. Steve Montgomery is here as well, affectionately known as Monty. First, thank you all for putting together this hearing tonight. I know that it's later than you normally meet, and it's holidays, all those sort of things. So I appreciate you finding time to make this happen this evening. So, Kate, if we go to the slides, I will go over sort of the agenda that I'd like to go through tonight, and I will try to make this brief. So first, I'm going to go through our requests and some circumstances leading up to our request. Then we'll go through the exceptional practical difficulty standard, and we'll conclude with any questions you might have. Before we get started, I should ask, I saw Mr. Zolper texting. Are you asking Dawn to weigh in if she has anything to say? I want to make sure that public hearing is fully rounded out if there's something she wants to get on the record. Thanks. Oh, next slide, Wood. So this is a quote that I love. I show it to you guys, I think, every time that I have an application for Mr. Montgomery, but I think it really kind of says the essence of how he feels about Dewey Beach. This is from the News Journal from 2018. There, it said, and yes, he has heard requests for a starboard in other towns, but he refuses. It just could never be the same, and he doesn't care to try the experiment. He's worked too hard to build up the brand to sell it. I laugh when I hear it, said Montgomery. The Starbird is what it is because of Dewey Beach. So that's just sort of where he is. He's had some pretty good accomplishments along the way. Next slide. Most recently, next slide, he's probably accredited with one of his greatest accomplishments of all time, which is making the Orange Crush the official state cocktail. So thank you, Mr. Montgomery, for that. Okay, so what is our request? Our request is basically a modification of what this board did a few years ago in granting relief so that we could have an outdoor dining tent and some outdoor uncovered dining space as well. So we're requesting that the Board of Adjustment grant variances to permit the permanent outdoor dining tent to be converted to a pavilion structure, and we'll get into why exactly that request has come about, but that is the basic request. There's 4 different variances, as you've seen, but it really all boils down to, do we have an exceptional practical difficulty that would permit you all to grant the relief required to convert what you see there to a hardened pavilion structure, more weather resistant than these tents seem to be. Next slide. So as Mr. Townsend mentioned, there are 4 different requests for relief. The first request is a variance to convert the permanent outdoor tent approved in the board's May 5th, 2023 written decision to a weather-resistant pavilion structure with fire suppression sprinklers. We're going to get into the fire suppression issue in just a moment. The second is a request for a variance or special exception to expand the covered outdoor dining area authorized in the board's May 5th, 2023 written decision to 1,579 square feet of covered outdoor dining area with 11 dining tables. The original approval was for a tent of 1,200 square feet. This is for asking for 1,579 square feet, and I'll explain why that increase in space as well. Next slide, we're asking for a request for relief to permit an expansion or addition to a non-conforming restaurant or outside service area to permit the construction of a 1,579 square foot pavilion. And then finally, we're asking you to continue the waiver that was granted previously to continue relief from the off-street parking requirement. So we haven't had a parking requirement now for a few years, and this tent has been in place for a few years as well. So if that relief is granted, what's on the screen now is what we'd like to construct in place of the tent. As you can see, it has sort of the beachy look that has been growing up in Dewey Beach over the past several years. I personally think it's a much more attractive structure than sort of what looks like a temporary tent sitting in a parking lot and what's been there for the last few years. No offense to what you've done with it, but I personally think that this is a more attractive corner for Dewey Beach. You'll notice that the roof kind of slants backward toward the main structure. I'll explain why that is later, but basically that's to deal with a stormwater management drainage problem. Right now, all the water that falls on the tent drains into the pedestrian area and is not collected in any way to manage it as stormwater. This will allow us to drain the water off the pavilion roof onto the main structure roof into a gutter system and then properly be managed as stormwater. And that's why that roof is sloping that way. Here it is from coastal highway in an elevation. The next one shows it from Salisbury Street, and you can see that sloped back roof and how it slightly overhangs.
Where's the shark gonna go?
Oh, there's a question.
Just, I'm kidding. Go ahead.
So the next slide provides some notable facts, and this is why I think, sort of these facts sort of give the essence to me of the exceptional practical difficulty standard, which we're going to get into in some more detail. But remember, I sort of preach that the exceptional practical difficulty standard is a balancing test, a test between the harm to the applicant if he's not able to do what he wants to do versus the harm to the neighboring properties if he is able to do what he wants to do. So one notable fact relates to the dining tables. The 2003 approval permitted 20 outdoor dining tables, and although the proposed arrangement swaps out the number of covered and uncovered tables, the total number of tables will not change, meaning that the total number of outdoor diners will not change. So the 2023 approval permitted 11 dining tables in the area outside of the tent, and then 9 dining tables inside the tent. We're just proposing that those be swapped, and there would be 11 this time under the pavilion and 9 outside the pavilion. But the number of total tables does not change. So I can't envision any additional impact to neighboring properties based upon the number of people who will be dining at any given time in the outdoor area.
Greg, while you're there, just
Sure.
one question while we're here, just real quick. And it wasn't explained in 2022. Why are we talking about tables versus seats and pedestrian or patron area? Because the table can be 8, can be 4, can be 2, so.
Good
Help me
point. We,
understand that.
and maybe we'll get the owner up to
later.
talk about that.
Okay.
But as far as patron area, we will talk about square footage in a minute, just to make sure that everybody's aware of what the exact square footage is. We will be subject to, our site plan though, and the number of tables that it shows and chairs that it shows will be, the permitted site plan for this space. As it relates to drainage, I did mention that the roof line of the pavilion will be extended to address stormwater management, resulting in the covered pavilion area being 360 square feet larger than the approved tent area. So why does it grow 360.6 square feet? It grows because the area right now at the back end of the tent, between that area and the front of the main starboard structure, is kind of an open area right now. And that tent does not extend as far as back as the main structure is. By extending that roof line, as I mentioned, extend the roof line so that you can then capture that water on the roof of the main structure, and then that water can be contained as stormwater. But that's the reason the building is growing, is to extend the roof line back to overhang the main building.
So it's not coming forward toward the street, it's going back?
Correct.
Okay,
That's right.
just making sure we're clear.
The uncovered outdoor, and on my slide it says dinging, it should say dining area. Sorry about that. Will remain as previously approved. So the area in front of the pavilion, which is currently the outdoor dining seating area that's outside of the tent, that stays exactly the same at 536 square feet. Again, the tables swap in those two areas with the same number of tables. And then finally, the pavilion will have a fire sprinkler system, and that is largely the reason that we're here tonight. There's a requirement in the Life Safety Act that requires now, or at least the fire marshal is now enforcing a sprinkler system requirement within the tent, which is existing there now, or within this pavilion structure. This structure is going to allow us to incorporate a sprinkler system within the structure itself. If we did it within the tent, you'd have to have a standalone sprinkler system that you could wrap the tent around, because the tent needs to be replaced. I think you've told me that you've had to replace it 3 times already since it's been approved, because they just don't withstand the weather over time. And so building a standalone sprinkler system that the tent comes up and down and off, and it just makes it difficult and expensive to do it that way. And this is a better approach. So the result really here, when we talk about the balancing, there's no change in the occupancy, same number of tables, so no negative impact on the community, but the community gets the benefit of increased stormwater management and a life safety enhancement in this fire sprinkler system. So as you balance those things, it seems to me that the community in many ways is getting an upgrade rather than a downgrade. So next slide, this is the timeline to outdoor dining. I'll try and go through it pretty quickly, but just to give you a little bit of context, the Starboard was built and opened by Duke Dugan in 1960. It was a full 21 years later that the town incorporated as the town of Dewey Beach. And then a year after that, Dewey Beach adopted the comprehensive zoning regulations. So it was a full 22 years the Starboard was already in place before any zoning regulations were in place. And that's why it exists today as a legal non-conforming structure. There was no zoning for it to comply with at the time because zoning wasn't in place. In '86, Starboard changed hands again, and then 1 year later, Monty, as a young Monty, not that you're not still a young Monty, was hired as a summer employee. Flash forward a little over a decade later, and he purchased the place with some partners. Pretty impressive to make that happen in a short period of time. Flash forward another couple decades, and we get hit with the COVID-19 pandemic, and that's where we all started thinking more seriously about outdoor dining. March 18, there was an order by the governor to close restaurants down. Then by May, the order was modified to permit outdoor dining. And in February of 2022, the General Assembly passed a bill that intended to make outdoor dining permanent. But of course, the municipalities have the zoning authority and the state can't really infringe that zoning authority. So the municipalities engaged in activities to issue its own approvals for outdoor dining, which the town of Dewey Beach did, but it basically did it for all these restaurants that are approved pursuant to a conditional use. The Starboard is not approved pursuant to a conditional use because it was grandfathered in based upon its prior status. So it had to go through a different process to approve those outdoor areas. Namely, it came here to the Board of Adjustment, and that was the result of the 2023 written decision. Anything else on that slide I wanted to mention? So in 2024, then, earlier this year, we were informed by the Office of State Fire Marshal that provisions will be enforced that will require the existing arrangement, the existing tent, to be sprinklered. And that brings us here, December 19, 2024, asking for relief from you all to be able to modify your prior decision so that we can create a pavilion structure that would be able to handle the sprinkler system and deal with the stormwater. So this here is the life safety code that the fire marshal is beginning to enforce as it relates to these spaces. This first section says that if you are a structure that's in place for 180 consecutive days or more, they're going to start looking at you. The next provision says if you're a space or an assembly or an occupancy that holds 50 people or more, you're going to be in this category of of businesses that need to be sprinklered. And then finally, on the last section, there's the 6 instances where the sprinkling is going to be required, and number 4 and 5 is bars and restaurants. So that's the provisions that are going to be enforced by the fire marshal as it relates to this property. So I should mention there that for other areas around town that might have outdoor dining and some sort of tent over it or something to that effect, if they're not housing 50 or more people under that space, then these provisions would not apply. So I can't say how many areas there are in town that this does or does not apply to, but those are the requirements. 50 or more is an occupancy space. The structure has to be in place 180 consecutive days or more, and bars, restaurants, dance halls, nightclubs. Okay, so getting into the exceptional practical difficulty standards. This is kind of the boring stuff, and it'll go fast, I promise. If the other stuff wasn't boring enough, we'll get going on this. So the Delaware Supreme Court, in a case called Newcastle versus Quick Check Realty, this is the case that's always cited for the 4 factors that you all have to go through. The Delaware Supreme Court said such an exceptional practical difficulty is present where the requested dimensional change is minimal and the harm to the applicant if the variance is denied will be greater than the probable effect on the neighboring properties if the variance is granted. Kind of that balancing thing. I didn't used to quote this next case, but I do because I think it kind of does boil it down in a way that it makes sense in my mind, this boiling test. So this is Conway and Conway versus Zoning Board of Adjustment, this is the Delaware Supreme Court, and it said the quick check analysis is a determination as to whether the appellants are experiencing exceptional practical difficulty in their efforts to make normal improvements to their property, which in turn is decided by weighing the interest of the applicants against the interests of the public. The balancing of competing interests is the essence of the quick check test. And that's how I see it. There are 4 factors that you have to go through, and I'm going to go through them right now quickly. But it really comes down to take a look at the harm to the applicant versus if the variance is not granted, versus the harm to the neighboring properties if the variance is granted. And I'm submitting to you tonight that there's virtually no change for the public other than life safety and increased stormwater management. So this next page tries to articulate the exceptional practical difficulty, and I say here the exceptional practical difficulty arises from the condition that while a past approval of the Board of Adjustment permits permanent outdoor dining, current life safety code makes it impractical to maintain the outdoor dining without converting the fabric tent to a hardened pavilion. A further exceptional practical difficulty arises from the condition that without extending the roof lines, a proper stormwater management system is infeasible. So there are 4 factors to go through, and I'm just going to go right into them now rather than reading them all. So the first factor, next slide, is the nature of the zone in which the property lies. In this instance, the property is in the Resort Business District, or RB2, where restaurants are permitted by conditional use approval, and it's adjacent to Coastal Highway, where commercial activity is expected. Starboard has existed in its present location since 1960s, so this is in the perfect location, in the perfect zone, so this factor favors the granting of the variance. The second factor under quick check is the character of the immediate vicinity and the uses contained therein. Many of the buildings immediately surrounding the Starboard are commercial and have a restaurant use. Indeed, I should point out two blocks down, Jimmy's Grill has what is essentially an open-air covered pavilion, sort of as we're proposing here, and consequently, the proposed pavilion conversion is in character with the surrounding buildings and commercial uses, and this factor also weighs in favor of granting the variance. The third factor is whether, if the restriction upon the applicant's property were removed, such removal would seriously affect such neighboring property and uses. And here, granting of the requested relief would not seriously affect neighboring property. A permanent tent structure is already approved. It's been there for a number of years. The conversion from fabric material to a hardened pavilion will enhance the streetscape and will not negatively affect neighboring property and uses. And because no additional dining tables are proposed, there should not be a noticeable difference in the number of outdoor diners. So this factor also weighs in favor of granting the variance. And finally, the fourth factor and final factor is whether, if the restriction is not removed, the restriction would create hardship for the owner in relation to his efforts to make normal improvements in the character of that use of the property, which is a permitted use under the use provisions of the ordinance. So the current status of this property is outdoor dining, and an outdoor dining tent is permitted. If the variance is not granted, the owners will not be able to install and maintain the required sprinkler system without great difficulty and expense. The sprinkler system is clearly a normal improvement as it is required by the National Fire Protection Association's Life Safety Code. Further improving the site's stormwater management system is also a normal improvement the owners should be permitted to make. So this factor kind of makes me think about a couple of things, because I do think it votes in favor of granting the variance, but I'm sure some of you are thinking in your mind sort of, you asked for relief to have an outdoor dining tent, and now you're asking for further relief from that relief because, and is that appropriate? And I guess the couple things I would say about it is, Code Section 185-71 sets up a procedure. It's titled Amendment of Special Exception or Variance. So the code, Dewey Beach's code, does anticipate modifications to variances. So I don't think there's anything inappropriate about asking for a prior variance to be modified further based upon some new exceptional practical difficulty. So that section says the procedure for amendment of a special exception or variance already approved or requested for a change of conditions attached to an approval shall be the same as for a new application, except that when the town building code official determines the change to be minor relative to the original approval, he may transmit, or in this case, she may transmit the same to the Board of Adjustment with the original record without requiring that a new application be filed. We didn't ask Ms. Hinks to do that because we do know this is not an insignificant change to the prior approval, so we submitted an entire new application as this code section anticipates. The other thing I'd say sort of on that idea of, isn't this really a variance to a variance, is that, sometimes we overthink these things. And, I went back and forth with how to sort of think this through. So I went back to the state code. And so Title IX of the Delaware Code says that the Board of Adjustment is authorized to grant a variance where, owing to special conditions or exceptional situation, a literal interpretation of the provisions of any zoning ordinance, code, or regulation will result in unnecessary hardship or exceptional practical difficulties to the owner of the property. So if an owner is permitted to do something under the zoning ordinance or a zoning code or a zoning regulation, here I would say under the decision that you all made and issued, that's basically the zoning law for this property. So if an owner is permitted to do something under the zoning ordinance, code, or regulation, like having an outdoor covered dining area, as is the case here, he should be allowed to pursue it. Should be allowed to pursue that which is allowed to be done on the property. Then if something prohibits the owner from making the use of his property, which is permitted, then we come to this board. So in this instance, we're allowed to have a covered outdoor dining area. It specifically says tent in the written decision that was issued in 2023. But for reasons that have surfaced now relating to the fire code, that tent is no longer practical, and in fact, it's impractical. And that's why now we engage with the Board of Adjustment. But I want to be clear about something that what causes the exceptional practical difficulty is not the relevant issue. So I don't want to be confused that, wait a minute, this is a fire issue, not a zoning issue that's creating the exceptional practical difficulty. For example, the basis of an exceptional practical difficulty can be the ability to remain competitive economically with your competitors. Staying competitive economically isn't a zoning issue, that's sort of a real life issue. So in this instance, a fire suppression system isn't really a zoning issue, that's just a separate regulation that's now been enforced against this property. But that doesn't mean we shouldn't be able to pursue that which is permitted on the property, which is outdoor dining in a covered area. So we have a practical difficulty in continuing to do something that we have the right to do, largely because of the enforcement of this fire code. So the next step, when you get into that situation, the next step is logically to apply the quick check factors, which we just did. You shouldn't start, I guess, with the notion that there's no exceptional practical difficulty because having a tent is not required. I'm concerned that some of you might be thinking, well, they asked for a tent, they don't need a tent. That decision's already been made, that we have an exceptional practical difficulty, it's just that we should be allowed to have outdoor dining and an outdoor tent. So shouldn't start with, the tent is the problem. The tent isn't the problem, the tent's already a permitted use. The fire suppression requirement is the problem. So this next slide, I'll go back to the Delaware Superior Court statement that the quick check test is really the balance of competing interests, and that's the essence of the quick check test. And here, where we balance the interests of the applicants against the interests of the public, it demonstrates that an exceptional practical difficulty exists such that the applicant should be granted the relief requested. Again, when you boil this down and really just do a straight balancing test, there's no change in outdoor dining occupancy, same number of tables, so no negative impact really to the community, but the community gets better stormwater management for this property and life safety is enhanced. And let me be clear, Mr. Montgomery, we've talked about it several times, and he has no problem with the sprinkling requirement. In fact, he said, running the pool, other things that happen there, we should have sprinklers. It would be awful if something broke out in there and it wasn't sprinkled. So that is, the issue is not that we don't want to do the sprinkling. The issue is that we want to do it right, and the right way to do it is through this Hardin Pavilion. So we do respectfully request that the board grant the relief we've requested, and I'll leave you with just one fun fact, which is that the comprehensive plan really does kind of promote family-friendly activities around town. And one thing that Monty has noticed is that outdoor dining leads to more family dining. And in fact, his ratio of food sales to alcohol sales has increased since he's had the outdoor space. And I think that's probably a good thing for Dewey Beach. With that, I'm happy to answer any questions you have. If you have questions for architects, happy to answer those. And if you have anything for Mr. Montgomery, answer those as well. Sure.
Got a question for Mr. Montgomery. Play the devil's advocate here. If your variance requests don't get granted, what would you do then?
So I'm gonna swear you in.
Oh, I'm sorry. Go ahead.
That's right.
Just name and address for the record, please.
Steve Montgomery, Starboard address?
Yeah, that's fine.
2009 Coastal Highway.
That's fine.
Dewey Beach.
And do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. What will we do if we do not get this?
If you do not get the variance request that you're having tonight, what would you do with your current situation, the tent and so forth?
I'd probably continue. We've done this for 4 years. It's, I'll start by saying this was an idea to try to do something, an improvement to make it look better. Because as said to you, it looks like COVID today still. Something we don't. This is a silver lining from COVID, but we do not want to be continually reminded of COVID. I didn't think it would be that big of a deal to need all this legalese when we first came to this, but then you realize you start talking about doing this and you're like, oh, we got to make sure we cross every T and dot every I to make sure this is done correctly. So I've been focused on this for 8 months or so to do it. If we don't get it, we're going to continue to operate the way we are. It's just, it just doesn't, I don't know what I would do with the state fire marshal because that was new. We've replaced awnings. We lost our awning shop in Dewey when Collier sold. So there's literally no one close by to work on awnings. So that's why I've replaced our physical awnings that have been on the starboard for years, for decades.
Fire or marshal requirements, your current situation with the new changes coming on would prohibit you from having that tent situation?
Fire marshal requirements, anything over 6 months, everything over 6 months have to be sprinklered. So we would have to remove the tent,
And do
the
the
back, and do it
hard
all.
way with sprinkler.
Right, so can you talk just for a moment about the practical difficulties in continuing to operate with a tent versus a hardened pavilion structure? What would it mean for you? Like, what sorts of things would you have to be doing? For example, removing the tent every time that it, became weathered and putting it back up, and how would you build the sprinkler system? What's making it difficult for you to continue to operate the way you are versus?
I could not sprinkler a tent. I mean, you get one gust of wind and that tent is a kite. So we'd have to take that thing down. We do take that thing down for every storm, winter. We're one of the few year-round businesses in Dewey. We're trying to promote year-round business in Dewey. And, a difficulty is to be able to do that. I can tell you, right now we have a state police Christmas party going on. The dining was supposed to be outdoors. Well, it's freezing tonight. So now they're squished in and it's just, there's a lot of day-to-day difficulties with running a restaurant that is year-round in a beach town that has a wind tunnel coming up Salisbury Street, is my difficulty in the operation.
Okay. We heard all the positive benefits to the town and community with the changes you're asking for. I didn't hear too much about the detrimental part if we didn't do this. That's all I was asking, just so I
Sure.
could compare the two, pluses and minuses, that's all.
It honestly, I was going to talk after he did it. This outdoor dining thing has been, we've all talked about this. It's been wonderful for this town, this community. Dewey Beach is place people come to eat today. 10 years ago, I'm not so sure that was the case. It's looking around at what other businesses have done. It makes me a little bit proud because I was instrumental with our governor and with Pete to get this formalized and get it kind of where it is. And I'm always somebody that's thinking ahead on what can be done. I mean, I look at Dewey Beach Dewey Beer Company across the street, and I love that place, and I love the look of what they've got. We're in a different spot because it's so much of our dining we have Starboard is 65 years old. Its dining area is very small. Its bar area is very big. It's the way it's been. This has drastically changed the Starboard's what we are into a restaurant with a bar rather than a bar with a restaurant. I think that's the direction this town likes. We all like it. You know, I looked at our upstairs roof of Starboard Claw, and I'm watching them build that deck at Jimmy's Grill this summer, and I'm like, I wonder how that's going to work out. Personally, I think it's wonderful. There's people are sitting, dining, enjoying the outdoors of Dewey Beach. It's part of what makes Dewey Beach so much more special than a lot of our neighboring towns, besides dogs on the beach. It's outdoor, you know, we are the town that everybody wanted 25 years ago now. We're much more well-rounded, the year-round. I mean, Diane Hansen, we're talking about her, walked up to me last week and she just thanked us for the Christmas decoration. She goes, it's so nice to see Dewey Beach alive in the winter. And I said, this is what we've always talked about, and now everyone seems to be jumping on board. So that's kind of the direction with making this a formality, in my opinion, that thing is not, you're not up all night every time there's a storm watching the tent bounce up and down, worried about a tent. It is meant for a weekend event. And, you know, some of the drainage and stuff we're talking about, you can't use it when it rains because the water's just coming in everywhere. The wind's coming sideways. And these fine people at Fisher have been through about 12 different renderings with me because it was everything from the Taj Mahal to I wanted something simple. Like, I wanted to be Dewey Beach, wanted to blend in with we'll call it the charming architecture of the Starboard. And it still looked like Dewey Beach when people, because it is one of the first businesses people see when they're coming from the north end of town. We wanted it to blend in. So that's kind of where we've come up with this design.
Dave, I'm going to go to you. Do you have any questions for Dave?
Oh, no, I'm good. Thank you.
Are you good? Do you have any questions?
I do, actually, more for the architect side, and maybe you as well, Monty.
Before Monty, before Monty sits down, let me, because you might have questions there too, but let me ask you that you've heard all the testimony that I kind of gave on your behalf. Do you adopt that as your own testimony?
Could I adopt it as my own testimony?
Do you adopt?
Yeah, all that you said was true.
There's an old case that says lawyers can't give testimony.
Yes, I did ask him to keep it simple, and that's as simple in his world.
I think.
So,
Mr.
Mr.
Johnson
Montgomery, you mentioned that the tent has been replaced on numerous occasions.
Yeah, I think this is the third tent in the last 3 years.
So, what have you investigated what it means in terms of the issue of the applicability of the fire marshal's standards, that if the tent is in place for more than 180 days, then it's got to be sprinklered. So has it been in place for more than 180 days? And is that really a difficult challenge for you to take the tent down? What does it cost to take the tent down? What does it cost to replace the tent?
It's quite a challenge to take the tent down because we have, you know, especially this time of year, because we've got sidewalls and trying to keep the wind out from underneath of it. It takes 10 people hours and hours, and we take it down for some of the events like running of the bull and things like that. We take it down for storms. We take it down in January, February, because snow, that thing's not going to, you know, we're unable to operate in snow season with the tent. None of us want to be under there. I actually have pictures of that tent right around 2020, I guess right when we first did it, when it collapsed. I was very smart and I backed the Starboard pickup truck under the tent thinking it wouldn't fill with snow, and it was snowing so hard. And I woke up to the tent collapsed on top of the pickup truck. So that's one of my
So
friends.
if you're taking the tent down once a month or even more often than that, are you still subjected to the state fire marshal regulation that says that it's got to be sprinklered?
We're taking it down due to weather. We're not taking it down because we want to.
Well, I know, but it's still not up 180. I mean, it doesn't have to be up 180 straight days. If you can take it down and take it down as often as you do, is it really?
It's up for more than 180. It's the off season. We have not to date had any storms or hurricanes during the summer season when it's up March, April, May, June, July, August, September, November. It's December, January, February when we've taken it down.
Would it be exceptionally difficult, though, to take it down once a month and then put it right back up so you're complying with so that you would not be required to have a sprinkler system? Would that make your business operation and your ability to have what's a permitted use, which is outdoor dining tent, would it make it exceptionally difficult if you had to take it down once a month and put it right back up?
It'd make it extremely difficult because you'd have to you wouldn't be able to use that area to do so. I mean, it takes, lifts and things that get the thing up and down. It's a big tent. It's not a 10 by 20 tent. It's a big tent. So
Does
it's,
your staff do that, or do you have to?
regrettably, yes. They do it with Grand Rentals' help with some of their machinery.
And you take that tent down roughly how often over the course of a year?
Probably 2 to 3 times a year in the winter time.
Not in the summer?
Not unless we got a hurricane.
Is it, can you assign a cost to that? I mean, obviously, it's not specific, but what does it cost? I mean, what does it cost to install the sprinkler system? Or is that even possible?
Well, I can tell you, we just spent about $30,000 to do the awnings that were just replaced with sprinklers, expanding our sprinkler system. So that the tent, I believe, is going to be about another $23,000 to $25,000 to sprinkler it. I mean, it's a substantial cost to do what we're talking about doing, but it alleviates loss of business, it makes us more year-round, and it, helps us to operate on a more consistent basis. I mean, I can't tell you how many wedding brunches in the fall, and I say the fall because that's when you get the crazier weather, get canceled, get moved the night before the wedding because you got rain. And I don't want to deal with those moms, those wives' moms.
So when we have rain, if you've got this new pavilion structure, you're going to have retractable walls that are going to come down.
Correct.
Do we have any images of what that's going to look like?
Images, no, it's just the same things we have I would just visualize on the rooftop of Starboard Claw right now.
Almost like garage door.
No, not garage, it's just clear awnings, just same thing Royal
Like
has.
the clear plastic.
Clear plastic,
To just
yeah.
enclose it, yeah.
You
Like
know,
Woody's has in there.
Woody's has, Dogfish in Rehoboth has, Green over in Lewis by the ferry has. You see them pretty regularly these days.
They're
Right now,
required
your
to be
tent is.
transparent, isn't that right? Or at least the tent is required. to
Ours would be
transparent.
transparent, I don't know if they are required.
I think the tent is required by ABCC to have clear walls.
Really.
So
News to me.
ABCC can see what's going on without entering the tent. You have clear, I noticed tonight, you've
Yeah.
got clear.
Yeah, I'm claustrophobic, I don't like. And I honestly think seeing people seated dining in that starboard parking lot we come to Dewey is a huge advantageous to what this town, the direction this town is going. I mean, the amount of, and this is backtracking, the quality of dining customers that have come in the last 3.5 years is drastically improved. And, I can tell you, because we had so many hearings building Claw, how many people are like, we didn't used to go there. We love having breakfast there now because of the outdoor area. It's the first, it's our spot.
Dave, does this conversation spark any other questions for you?
I don't think so. I was trying to think back about when in 23, when we made the decision to make the permanent. I mean, my question is about the parking thing, but we've already decided that the limitation of the parking requirement has been granted, right?
Right,
Yes.
yeah, so to me, that's kind of a moot point. I feel like that's something we've already been okay with.
Right.
But obviously, we're not to that point
Yeah.
yet, but I agree with you.
But Mr. Mandalis, you included that just really out of
Abundance of
overabundance of caution.
Correct.
Yeah.
Just to make clear that what's in place is sort of remaining, we're just modifying, what's there. So maybe that was more than I needed to, but I want to certainly be clear that that's still a requirement.
Anything else, Dave? You have any other
No, that was, I think
Okay.
I understand, yeah.
Okay. Any?
So, yeah, I
Other
guess
questions?
I'm trying to get to the more, how permanent is this permanent structure? So maybe, I don't know who it goes to, but are you doing a subfloor, new air conditioning systems, new heaters? So will it still be on the asphalt? It'll still,
It'll be on the pavers.
Yeah,
I mean, I
pavers.
termed it a pavilion because I think of golf courses that have the little pavilions that you go to afterwards with picnic tables. We're still gonna have the exact same tables that are there now. 99% the exact same layout that's there now. It's,
keep all of that shed roof on that piece that kind of pokes out with the bar there. Still drop downs in there, so.
yeah, I mean,
separated.
we don't have to, because we have the pavers, we don't have to build
Yeah,
up.
yeah.
We did it nice and high, so it was airy and roomy. We have a lot of events, and it's kind of nice to have the height, and the water drainage is really the thing that I mean, honestly, when you're going through this process,
Yeah.
the word
I've
that,
been in there when it's pouring.
well, the word that changed this whole thing was the word tent and everything that was approved. You know, Dawn and I had spoken, and she's, you know, everybody's kind of in agreement, and this is a neat idea, this would look good, and all of a sudden, there was a screeching halt when, wait, the approval is for a tent. So, you know, there's a lot of T's crossed and I's dotted, as I said before, to make sure we do this properly, because we should have talked about this 2 years ago, a year and a half ago, but
And I will say, like, when I first read through the application, the thing that kind of caught my notice that concerned me was the extension of the square footage, because, you know, we were very clear about how far the tank could go out, but now that I understand that it's coming backwards, it's not going forward.
it's the same distance out, you know,
Right,
nitty gritty stuff. Towards the entrance, it's a couple of feet just to get to the drainage, because it's a standard tent that you order on the website,
Right.
so this is custom, so we can make it,
right, that
best it can
alleviated
be.
a lot of my concerns, because that was was the expansion, because I thought, I envisioned when I saw the square footage going out, and we were, as the board, were very clear about.
if you'd like to approve me to put the tent over the shoulder lane, I'll take it all the way out.
Now you can sit down.
Okay, buddy.
And then just to be clear, sprinkler system, that, the code has always been there. It's just, we're hearing now the fire marshal is gonna
Yeah, you know, honestly,
hold people
the fire
accountable.
marshal's office is no
That's
different
strange.
than alcohol control and everybody else. They didn't really do their jobs during COVID very much because it was COVID. They're all really doing their jobs well right now, and they're out enforcing everything, they're double checking on everything, they're going back and revisiting things they have. We have a brand new state fire marshal here, and he's wonderful, and he's checking, he's about safety and common sense, and I can tell you, when we did the awnings, you know, that was because Colliers would go, we had nobody to fix the awnings, and they too don't like storms, and it made the building so much safer having permanent awnings. And then all of a sudden I got the call, you got to sprinkle them. Oh, you know, nobody wants to hear that. But at the end of the day, I run a business and I want to sleep well at nights, and I'd rather everything be done the right way from A to Z, and that's what I think this project would be.
Do you have any questions for either Mr. Mandelis or Mr. Montgomery?
I've got a couple things
Okay.
too. And it'll be for Mr. Mandalis. Could we go back to the slide that shows us the fourth consideration under exceptional practical difficulty? It was nearly the last. And Mr. Mandalis spoke at length, and he was addressing an issue. I don't know, I want to make sure that it's understood by the board what he was getting at.
That one?
It was the fourth, yeah.
There we go.
So when the section which authorizes the board refers to granting relief from zoning restrictions. And this fourth consideration refers to the same thing, whether if the restriction is not removed, the restriction would create a hardship or exceptional practical difficulty for the owner. The question I have, and I think you've addressed it, but if you could hammer it home a little bit for us, is what is the restriction in the zoning code that you're seeking relief from? Because there's no, I mean, there's no requirement that a tent be there. The tent is there because your client asked to have a tent. So that's the difficulty that I'm having with this application. What is the zoning restriction that you want relief from?
So Mr. Townsend, I'll go back to the state code, which provides that in Title IX, that the Board of Adjustment is authorized to grant a variance where owing to special conditions or exceptional situation, a literal interpretation of the provisions of any zoning ordinance, code or regulation will result in unnecessary hardship or exceptional practical difficulty. Here, the zoning regulation, in my view, is that this board has granted relief and has provided that due to an exceptional practical difficulty, the zoning on our property, his property, allows for an outdoor dining tent. Just like, for example, in the residential districts, the zoning code allows for a residential home to be constructed. So, for
That's not a
example,
restriction, though. That's a permitted use, not a
the tent isn't a
restriction.
restriction either. The tent is a permitted use. It's permitted now that this board has granted the
But our
authority to do it.
authority is with regard to relieving the effects of restrictions.
Right, the restriction is that it's a tent of 1,200 square feet, and the restriction is that it's a fabric tent. We would like it to be a hardened structure that will support a sprinkler system.
So basically, you're basically saying that the restriction is that we approved a fabric tent. And so that was the restriction that was placed on you. So you're seeking relief from that restriction of a fabric 1,200 square foot
Right.
structure.
My view is, as a lawyer, I relate it to a little bit like it's the law of the case. The zoning of our property now has a new provision that says you may have a tent of 1,200 square feet, and as tent is defined in the code. That allowance or that provision now is restricting us from doing a pavilion, which we need to do to be able to comply with the life safety requirement of a fire sprinkler system, which is our exceptional practical difficulty.
Fred, you look.
It's just unusual that the applicant came forward and requested permission to put a tent up. And now the tent they want relief from the relief that they were given. The restriction in the code is that a legal non-conforming establishment like the Starwood can't expand. That's the restriction in the code that they needed relief from when they came forward requesting outside dining, and that's what was permitted. And in addition to having outside dining, it was natural for them to want to provide some shelter for their diners, so they said also allow us a tent of a certain size. So that allowance was granted. And now it's that allowance, which they're not required to have a tent at all, that they want, is serving as the, is creating a difficulty for them. The tent that they've been permitted to install is creating a difficulty for them, which they're asserting justifies the construction of a pavilion on a legal non-conforming.
But I think the problem with that analysis is you started with, they don't need to have a tent. It doesn't matter if we need to have a tent or not. If the zoning code or the zoning provisions or this board has granted relief that allows us to have a tent, we should be able to pursue the allowance of that tent. And the analysis shouldn't start with, you don't need to have a tent. The analysis should be, you're allowed to have a tent, and is there an exceptional practical difficulty with having that tent? And we apply the quick check factors. I mean, the hypothetical that I was gonna offer you, and I'll try to do it, is, think, for example, and we'll do it in the residential context, I suppose we could do it in the commercial context, but imagine that a home is constructed on a residential lot, and the zoning code changes, and all of a sudden, that home now is a legal non-conforming home. It sits into the setback someplace and is now legal non-conforming. The owner came and asked for a permit to build a home, and they granted the home. And so now that the home is there and it's in a legal non-conforming context, if now the life safety code says that home has to be sprinklered, and the homeowner says, I don't have any place to put the pump for my sprinkler system other than in the setback, can they now not get a variance for that sprinkler because they asked to build a home and the home is sitting in a setback? And I just think it's not as difficult an analysis as, you know, you can run a lot of different directions with these things, but
I think it's a modification to, not an exception, but a modification to what you've already been granted a couple of years ago. And in the modification, it also includes another 379 square feet, which wasn't on the initial variance. And you did that just to structurally, it will abut to the corner of your building now, just to make it a smoother modification transition. So, I mean, I don't know the legal parts of this, but I'm trying to think the commonsensical way that you're asking for a modification, what's already been granted. Instead of a soft tent, you want a hardened structure, and you got some benefits to it, the fire safety, the water runoff, which I think are, you know, commendable, but you're really getting another 379 square feet, which is the ask, I think.
Well, I think, but it's
mean-
covered space, it's not necessarily,
It's a
I mean, it's
usable
still
space.
part of the, it's still part of what
They're within
Starwood's
the-
already been.
So
It's just-
within the setback, I mean, they're not asking
It's,
for it.
no, they're not, it's
Right,
just
just out to
literally
the edge of
from,
their existing building.
yeah, it's
Yeah.
from the back side of the tent back to the main building. It's not, and that was my concern when I saw the 379 square feet, is I was thinking they were asking for it to go forward, but it's not, it's to go
line
back
up.
to the main building, so it lines, the roof lines up.
I'm just trying to understand, Fred.
I know.
So,
No.
And I think I understand Fred's point too.
It's not typical, so it's not a kind of a dialogue or analysis that we would typically have to get into.
I think I was kind of going that where, how permanent is this structure? Because now you're talking about almost adding an addition. It was granted as a tent, so you have a full use for a tent, but now you're almost talking about an addition to the building.
But I guess
But it's really just-
a response to that is that the written decision does allow for a permanent tent. So there's nothing that prohibits us from having a tent up year-round permanently. So it could be, you know, in perpetuity, that tent structure can be there. So as to the question of permanency, you know, again, I think that question also has already been answered under the prior decision, is that we can have a permanent structure there. So the tent is a structure. We're asking it to be converted to a different
Kind of structure. Yeah.
type of structure, but still, yeah, it's anticipated that it will be there permanently.
That's fine. I'm thinking, how permanent is
understand.
this? In a year, do we get another, oh, we want to now put in windows, we want to put in doors, we want to put a subfloor, we want heat.
Well, I
Now we've now allowed a restaurant to expand, where the code is pretty clear on that.
Well, I think that
Without all of the other things, without
the fact
parking
that
and things
it's
like that.
more of a pavilion structure, I mean, that's,
If I read correctly, it doesn't touch the original building.
That's correct.
Do you want to ask your questions of the architect?
Yeah, do I need to do that formally?
Yeah.
Sorry.
Come on up, man.
so you get to get sworn in now.
I caught the Matt part. Yeah. What's your name?
Matt Parsons,
Matt Parsons, for the record. Your address, please.
Fisher Architecture, 542 Riverside Drive, Salisbury.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
So Matt just asked the question again, sorry. I read correctly that it doesn't actually touch the original building, right? So
Correct.
it's not-
Structurally, it will not be connected to the original building. The only way it will be connected is for stormwater drainage purposes. Yep.
Dave, do you have any questions for the architect?
I don't think so.
Okay, thanks. How about you? Any questions
Oh,
for the
I'm good.
architect? Well,
Yeah, I've
okay.
already involved myself enough.
Okay.
I'm good.
Okay,
Okay,
thank you.
great.
Thanks.
Julie, could I just try to
Yes.
clarify something? I want to make sure I'm correct on this. If this does get approved, it's still going to be dining only, that's not going to be stand-up, correct?
That's correct.
And then anytime they want to do something out in that area for like
It has to
running
have
of the
the-
bull or Dewey Goes Pink, they have to come back before the commissioners
to
You
get
get
their permit.
approval for that, just like they
Yes.
do now, right?
Correct.
Same approvals they've had to get in the
Single
past, they'll
event
continue.
approval.
Single event approval, yes. Right. Yeah, that is my understanding. So if none of the board members have any more questions for Mr. Mandelis or Mr. Montgomery or Mr. Parsons, we're going to move to public comment? Yes?
You can.
Is there
Yep.
anything else? Okay. Any public comment? Do we have anybody in the waiting room? Oh, no, we'll start with you. You're here.
My name is Hal Dukes.
Mr. Dukes, are you here on your own accord, or are you representing someone?
I'm here on my own accord and also representing some people too.
So,
So that's a dilemma for you.
so how about if I just simply administer the oath? Would that be
That'd
okay
be
with you?
fine.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Okay. I have property in Dewey Beach. I have the Adams Ocean Front, and I also have a property that's across the street from the Starboard Restaurant, which is 109 Salisbury Street. And I also have property on the ocean front there on Salisbury Street. And I also represent several people in the neighborhood. And we've all gotten together this past weekend about this request. And I think that Mr. Mandelis did a remarkable job covering the legal part of it, but there's a part that wasn't touched that I think that the town needs to look at. This town is changing. It's changing to become more family-friendly. And one of the problems that the people have in our neighborhood on Salisbury Street, and also the people who stay at my motel, is that they look for good family dining that's not overpriced. And so many people in my motel operation go into town and you pay $38 for a pork chop and $8 for the salad and another $8 for mashed potatoes, and you can't do a family of four every night. And they can go over to the Starboard Restaurant and have a good family dinner for a very reasonable price. And that's what's attracting people to this town. Now, one of the things that we have is that, and they touched on it a little bit, but the tent that exists there right now is basically ugly. I have to tell you that. And I've had a lot of our neighbors, the people in our neighborhood, would prefer to have this new plan done and approved. I think that's important for the town. If you look at the picture, it's remarkable compared to what's there now. In fact, a tent sometimes intimidates some of our people from the motel. They go down, they think there's a wedding going on or something like that. If you have a nice operation, and it is I think it'll be very good for the neighborhood. I think it's going to enhance the value of my property across the street because it looks better. You don't have the old worn out tent there. So speaking for the people in the Salisbury Street neighborhood, we're all for this. And I'm for it because I have a motel and our people want to stay in Dewey Beach and have dinners rather than have to go to Rehoboth or someplace else. They want to stay in town. So we're all for this, and please understand that I think it's important to understand, and this, people to understand Dewey has actually become a very, very family-friendly town. We don't even have groups that are moteling longer, it's all families. And if you want to know about it, go out on the beach at 6:30, and what's on the beach, the kids are playing wiffle ball and touch football and flying kites and things like that. That's what we wanted 20 years ago, and we got it now. So now we got to take care of it, and that's why I'm in favor of this. Thank you.
Thank you, Mr. Dukes. Is there anyone else in the building?
I make a comment? Just a comment.
You need to go,
Okay.
you actually need to do the whole thing.
My name is Billy Anchulis. I live next to Storm.
Okay.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole
I
truth,
do.
and nothing but the truth?
I do. I've seen the tent in the middle of a storm. I've seen Monty's employees frantically trying to make sure that tent gets down, and it's extreme. It's a lot of work. Them kids are dedicated. They go out there and they're doing everything they can, but they don't have time to get. You actually have to respond to the weather. It's not like a couple days ahead of time. They're out there when it's gusting, and God bless the kids. But it's not the best situation. My other comment is, it sounds like all they want to do is improve the current situation. They're not asking for anything more. And like the gentleman said, I live right next door and they've done, I love them. They're not a business, they're a neighbor and they're good people.
Okay, thank you so much for your comment.
Thanks.
Kate, do we have anybody in the waiting room that wants to comment? No? Okay. And if there's no one else that wishes to comment about this, I'm going to go ahead and close the public hearing. So, board members, we've closed the public hearing. We're going to discuss each of the variances. I feel like they're kind of grouped. I think, as Mr. Mandelis pointed out, and I agree, that the parking requirement we previously granted in May, I think that's kind of a moot point. I think that's something that,
I agree. I don't think this application jeopardizes their exemption or exception from
So I think
off-street parking, so I don't.
that's something we don't even
I
have
think
to
that
address.
I think all you need to say is that no variance with regard to that is needed. And you could that could be a tag along to whatever other motion that you pass.
Okay, so I would agree that that is something that has been addressed in the previous May 2023 exceptions that we granted, and therefore, like you said, this is kind of a tag along. But so the big question is, whether we allow this structure to be converted from the tent to a pavilion type of structure that not only does it, Fred, remind me, I mean, there are 3 different variances left. They're all kind of related to the same thing. Do we have to go through them one by one? Can we group them together?
Can we vote on them as a group? Yeah.
Right, can we vote on them as a group, what are your thoughts from your perspective? Because it's basically to have the pavilion structure with the additional square footage.
See, typically you'd have an ordinance provision from which you'd be seeking relief. The first request is regarding
Converting it to a,
converting the tent into a weather-resistant pavilion structure with fire suppression sprinklers. So if you authorize this, I think it's fair to say that because of the representations that have been made in the application itself, that
B and D kind of follow suit.
that the fire suppression is going to be included as a condition. I mean, that's,
And
if you approve it, it will be required to have fire suppression.
And then I think B and D kind of go together because it's basically asking for the square footage, that the pavilion can be the additional square footage from the 1,200 square foot tent, correct? If I'm reading that right?
B is asking to expand the pavilion by the 379 square feet and to reapportion the tables, not to add any new tables,
Right.
but to.
But then D also is talking about the 379 square feet.
D also, is that what you said?
Yeah, D
Yeah.
also basically talks about the
Yeah,
1,579.
and D is the provision which prohibits the expansion of a legal non-conforming structure. So I'm not quite sure how to answer your question. I think a single motion will do. You're going to have to address the expansion, the reapportionment of tables, and
Okay, well, we can, I guess, do
Stormwater.
that. And I usually end up doing the motion anyway. Dave, do you have some, we're discussing now, do you have any comments you'd like to make about your thoughts on these variances?
You're asking me?
Yes, I'm asking you. I'm starting with you because you're on.
All right. Well, Fred's analysis, I mean, is interesting, I guess, is a legal issue about what exactly relief from what is. But I understand generally what's being requested, and assuming that we have legal authority for it, I would be willing to take up each of those matters. Yeah.
Okay. Comments, thoughts?
Yeah, I'm back to this tables versus people thing, because all our code talks about people and all of that, and this particular one talks about tables.
Well, and
Is there a
I,
legal reason? Just simple.
So the original variance,
Yeah, I remember that.
the original variance, I think, has a capacity element to it,
Okay.
it does,
right?
yeah.
Because we talked about the size of the tables, the number of patrons that could sit at a table, and then the number of tables. So they're not asking for a variance from the capacity restrictions of their original variance.
Yeah, it's just more from
They're
my
simply
understanding. When I
asking to-
listened to it, I didn't hear
Yeah.
anything.
So
So
That's-
the number of people at a table.
So-
It does not change capacity.
So they're not requesting, they're just simply asking to move, they're asking for permission to move one of the tables from the outside area into the pavilion that they'd like to construct.
Thoughts?
I think the COVID pandemic, along with Mr. Montgomery's efforts a few years ago, did the heavy lifting to get the initial tented temporary dining area. And it's actually been good that it happened, and we got to see it for a few years to see the net positive change to the community and the town. So it's been sort of not an experiment, but it was good you got a chance for people to see what you could do with that space. The question I asked you earlier, I was playing the devil's advocate. I wanted you to speak up. I wanted to hear your pain for financially what the cost, but it came out afterwards as far as how many times you put the tent down. That's the reason I asked you. I wasn't trying to bust your chops on that one. But anyway, I think overall the benefits outweigh any public negative impact, which I've heard zero negative public impact. So I'm good.
So I agree. I think basically moving this from the tent structure that we approved in 2023, in May of 2023, moving it to a more permanent structure, I think is beneficial for the town. I also think, the nature of the zoning is obviously, the Starboard is right there on the front of Route 1, which is a commercial zoning use. The character and use obviously kind of falls in line with that. I believe that the failure to remove this, especially given the new, or I shouldn't say new, but the zealous enforcement of the fire code and the sprinklers, I think does create an exceptional practical difficulty if we were not to allow the variance that would make this a more permanent structure. And like I said before, my concern was the extra square footage that was coming forward, not that's going back. But now that I understand that it's going back and it's not changing the structure of the tent, it's more practical, and it actually makes things better to have the stormwater issue resolved by extending the roof of the pavilion backwards toward the roof of the existing structure. So for all those reasons, I think, and I'm gonna let someone make a motion, and they can adopt what I just said, right?
Well, they can, but let's give the members a chance to make a motion, and then we'll see if
Oh,
we
no, I
can
know,
work
I'm
through.
just,
Yep.
because we've done that in the past where I kind of laid it out and then everybody,
Just signed on. I saw that in the last meeting.
yeah. But obviously, if anybody has any other reasons for their motion, I'm more than, obviously, you're welcome to make that motion.
I would a motion to approve, given many of the reasons. I think there are some exceptions that we had noted in the previous application around, and I don't know if we need to say this again, around closing at 11, no serving drinks while not seated. I think there's one or two others.
So there's several, there are code requirements,
Yep.
and the applicant is not requesting relief from
Exactly.
those, so they're still applicable. And to the extent that the applicant is not asking for a variance from any of the other restrictions that might have been in the original decision,
Exactly.
they still would remain
Would apply.
applicable.
Okay, great. Yeah, I think the exceptional practical difficulty is removing this tent when it's very unsafe for your employees and patrons. And I think my concern was how permanent, because but if we're keeping it pretty much the same and it's just a pavilion, then I would vote to approve.
So you're moving to approve.
Moving to approve.
Do we have a second?
I second.
Second. All in favor?
Okay.
Or are we doing discussion?
Yeah, so
Any
we're
discussion?
definitely,
Sorry,
yeah.
I forget. I
We-
jump
Is
ahead
there any more
sometimes. Sorry,
discussion?
it's getting late. I'm still
Yeah.
jet lagged.
So it's always important for the members to put their justification on the record, and of course, that might require you to repeat yourself, because you have said some things during the course of the meeting already, which you make part of your, play a role in your decision-making. Here's an opportunity, or at this point, it would be appropriate for you to give your reasons. So with regard to the motion, though, the motion is to, I think it's more difficult maybe to, in retrospect, to make this one motion, but I take it that the motion is to grant a variance necessary to convert the permanent outdoor tent to a weather-resistant pavilion structure with fire suppression. That, secondly, that the pavilion structure be permitted to be expanded to 1,579 square feet from what is currently permitted, with a reallocation of tables as applied for. And thirdly, that any restrictions related to the expansion of a non-conforming restaurant establishment be relieved as part of the motion.
Correct?
Correct.
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 And your second, and any additional reasons? You already seconded, but any additional reasons other than what has been stated?
Right.
Dave,
I vote in favor.
okay, do you have any additional reasoning from what has already been stated?
Well, I think that most of the reasons have been stated, but I do think that what is being requested is a normal use, given the exception that we've already provided. So it seems to me that it's consistent with what the standard is.
And I vote to approve based on the reasons I've previously stated. So that is a unanimous vote based on the 4 participants of the committee that are here today. So the variances have been granted. Anything else, Mr. Townsend, that we need to address?
I think that's it.
Then, based on that, any final comments from the board before we close the meeting?
Not for me.
Can I have a motion to adjourn?
Motion to adjourn?
Second?
Second.
All in favor?
Aye.
Aye.